Welcome to the Tinley Talks podcast, where we dive into the common legal issues facing today's community associations. Whether you're a manager, board member, or homeowner, you're sure to pick up on some nuggets of advice to help you build a successful community in this ever-evolving and changing world.
Hello, and welcome to Tinley Talks. I'm Ramona Acosta.
And I'm Tim Klubnikin.
And today we're talking about SB 326, the balcony bill, with Paul Pigott of EmpireWorks Reconstruction. Paul is the West Coast Regional Vice President of EmpireWorks Reconstruction, Construction Defect Services Division. Founded in 2002, EmpireWorks Reconstruction has local operations throughout California. Paul is a licensed general contractor who spent the last 14 years specifically focused on reconstruction for HOAs. Thank you so much for joining us today.
Thank you for having me.
So today we're going to talk about the balcony bill. The balcony bill was passed 2 years ago, went into effect last year, I believe, right, Tim?
Yes.
And it requires that balconies need to have their first inspection completed by January 1st, 2025. So we've got a little bit of time on this, but as we get into the nitty-gritty of this legislation, we're going to realize that we probably need to start working on this now. So, Tim, do you know anything about how this bill came about, what the impetus was behind it?
Yeah, so there were, I think there was one key event and maybe a few other kind of related ones, but essentially there was a tragic loss where a number of students in a housing project fell from a balcony that had collapsed, and I think 6 students died and 7 were injured. So at the end of the investigation, they determined that had the balcony been properly inspected and addressed for the issues that were identified or would have been identified, this event likely would not have happened. So at that point, many of the families of the students who had passed took it upon themselves to start to petition the legislature for revisions and reform to some of the obligations for condominium projects to inspect their balconies so that these events would not happen in the future.
So I think some of the confusion that many people have is I think that the perception was that, well, this was a college party. These were a bunch of kids that all piled on this balcony. They were all sitting outside. They were drinking, partying, dancing, and they weighed down the balcony, and the balcony fell. And so there's been they contributed to this crisis. But from what I understand, and from looking back at some of the old news reports and some of the legislative history, it looks like that wasn't the case, that there were mushrooms that were actually growing on the through the balcony surface, that there was dry rot damage, that there was an indication that this balcony had not been inspected and maintained, and that the kids had reported it to the landlord and to the management company, and that no repairs were made. It was essentially ignored. Is that right?
Yeah, I don't recall the specifics offhand, but from my original research, it seemed that this balcony was severely distressed from dry rot. As you said, there are clear indications that it was suffering from structural instability and that it needed to be addressed. And so, again, it's a situation where had it been addressed, it very likely would not have happened. Again, who knows what the load and the amount of people on there, but the issues with the deck were significant enough to warrant significant overhaul of the deck system. Absolutely.
And I've seen pictures of that balcony. After it went down, they were looking for contractors to go out and try to help them identify what happened out there. And I saw pictures afterwards, and the wood rot inside of that balcony made it look like it was on fire from the inside. It was completely black and rotted out. And if there was any inspection that had been done, it would have been immediately flagged and people's lives would have been saved.
So this is something that was entirely preventable.
100%.
So I think that, from our perspective, I used to be a manager. Tim, you've been an attorney in this industry for a long time. And I think sometimes we get pushback from some of our homeowners associations where the requirement or the recommendation is that you resurface the balcony every 3 to 5 years. You inspect it from time to time for the dry rot and the termite damage. And sometimes we get pushback from our associations because it looks fine. We don't have a lot of money. We don't want to raise our assessments. And I think this is kind of a gut check for all of us, and that these are the ultimate consequences if we're not fulfilling that fiduciary duty.
Yeah, absolutely. I mean, it's a great example of the real harm that can occur when associations fail to properly uphold their maintenance and repair obligations, which include inspection of major components. So absolutely.
So as much as this is going to be another burden, another maintenance burden, another financial burden, ultimately it's probably going to be good for the industry as a whole, I would imagine. So who does this apply to? From my understanding, there's a sister piece of legislation that relates to apartments, and then this is for condominiums?
That's correct. It's only for condominium projects. Yes.
Now, what about townhomes, planned developments? Not necessarily single-family homes, but they're technically a planned development, but they're attached. They're townhome style. They look like condominiums. Could there be some maintenance responsibility or obligation there?
Conceivably. So the language of the statute really turns on who has the maintenance obligation, the maintenance and repair obligation. So if you have a situation where it's a multifamily building of 3 or more units, and the maintenance repair obligation of the load-bearing structural components of the deck system fall onto the homeowners association, they should arguably have the obligation for these inspections under Civil Code Section 5551.
Okay, so I can't, as a manager, or as a homeowner association, I can't say, well, technically we're not condominiums, we're a planned development. If I have responsibility to maintain the exterior of the building, I have a responsibility to maintain the balcony or that deck structure. We could be subject to this bill regardless of whether it's a condominium or a planned development under that legal definition.
Yeah, I would think in the absence of any case law that comes out that clarifies the scope of this legislation, I think it's safe to say that if it's a building that has more than 3 multifamily units in the building structure and the obligation falls to the association to repair and maintain those decks, absolutely, we would recommend that they maintain and inspect under the statute.
Okay. Well, let's get into the meat of the bill itself, because it's pretty extensive the way I look at it. It looks like the first inspection has to be completed by January 1st, 2025, and then it needs to be completed every 9 years thereafter. And it's just an inspection requirement, it's not a repair requirement, correct?
That's correct. It's 3 or more units in a building.
Anything more than 3.
Right, okay.
And it's just CID, any common interest development is the only thing that it calls for. Anything that the community has to maintain. And the big thing too is that they're exterior elevated elements. And so you could have a 20-story building, but if it doesn't have any wood-framed exterior elevated elements, it wouldn't need to be inspected.
Right.
So wood-framed is important too.
Yeah, we've already had some weird ones where they have decks, but they're like recessed and but they're in the middle. They're really weird.
Or they have components of the deck that are wood, and then the other stuff is steel, and I've seen that where it's a steel frame structure, but then it has like wood sheathing, and even that has to be inspected.
Yeah, and one of the things, when we do our presentations on this bill, we've had some board members who have said, "Oh, well, we're fine. Our balconies are steel. We're great."
Yeah.
And I think about that, and I think about the community where I live, and I think, okay, well, I have concrete stairs with wrought iron railings, so good. And then you go upstairs, and the deck surface is concrete, and it's got a vinyl railing. So I'm like, good. And then I go back downstairs and I look up and I'm like, oh yeah, that's all supported by wood beams.
All of it.
Yeah.
So
it's just lightweight concrete on top of waterproofing, on top of wood sheeting and wood beams. So potentially cantilevered out, which is what you ended up having there in Berkeley when it collapsed. So,
So it would fall under the bill. So inspections need to be completed every 9 years beginning January 1st, and they need to be completed by a licensed architect or a structural engineer. Why does it need to be a structural engineer and not just any general contractor?
I think that's a good question. And we don't have a lot of background on the, well, I take it back. There is a lot of legislative comments about how this came about. But in terms of that particular point, it seems that given the significance of these types of inspections and given their intent to prevent life safety issues, it seems that they kind of upped the standards for the professionals inspecting it to ensure that the inspection is adequate. So a structural engineer is well equipped to evaluate a system to determine if it is going to be structurally sufficient to deliver the loads it needs to. And an architect generally will have the same kind of educational background to make those determinations. Not that general contractors could not do this. I'm sure there's many competent general contractors in California that would be well equipped to do this adequately. But for whatever reason, the legislature felt it appropriate, given the significance, to make sure it was done by an architect or structural engineer.
So why that is the case is also going back to 721, which is the apartment bill, right? And initially when they came out with this balcony inspection bill, which was 721, They said anyone can inspect it that's somewhat licensed or competent enough to do it, but you have to open up 20% of your structure. And the HOA industry said, no way, we don't have the funds to open up 20% of our structure, or 10, 15% or whatever it was, because you have these massive number of balconies on this, and it would bankrupt these HOAs. And so it went back to court, or back to the legislature, and the 721 continued ahead, and they pulled out the HOA component at the end. And then they came out with SB 326 a year later and said, okay, then what we're going to do is just that. We're going to take the requirements for who's inspecting, and we're going to increase that to make sure that we're getting competent licensed professionals on it, but we're going to limit the number of things that we are going to look for. And so instead of opening up everything, we're just going to do a visual observation of your wood framed components and the adjacent waterproofing systems. And so that's why those changed in the end.
And I think that makes sense too, because if you have, again, thinking about my days as a manager, if I ask a general contractor to go out and look at it and say, okay, inspect all of my balconies or inspect all of my exterior elevated elements and tell me what kinds of repairs that needs to be made, I'm incentivizing that contractor to find problems, right? Versus having, an independent third party. We talk about this in so many other areas of association law where we talk about you need to hire a consultant who's an expert in the field, an independent third party, because there is, the motivations are different.
But that's also why in 721, where a contractor can do the investigation, they can't do the repairs.
Right.
That's not the case in 326. So in SB 326, there is no clause in there saying that the person who's doing the inspections cannot do the repairs, because the person doing the inspections is a licensed architect or engineer, and they're not going to be doing repairs anyways.
Right.
And so that's one of the distinctions as to why, and there's a separation there.
Right. So the bill requires that the exterior elevated elements and their associated waterproofing elements are in a generally safe condition and performing in accordance with applicable standards. That's the actual language from the bill. And Paul, you've mentioned exterior elevated elements a couple of times. You've mentioned associated waterproofing elements. So in layman's terms, what exactly are we talking about?
We're basically talking about wood-framed balconies, decks, stairways, catwalks, walkways, anything that projects out past the building face that has some type of a wood component and a waterproofing system that's adjacent or as part of that assembly. And so private balconies is probably the biggest one that people are going to know, or exterior walkways. If those have any type of wood frame system where they're either cantilevered out or they're attached to the face of the building, those elements, because they're wood, have the ability to rot out and fail if they're not inspected, if they're not built correctly, if moisture is being trapped inside, just like we had with the Berkeley collapse, and that wood continues to rot out without inspection. So those are what the EEE, or exterior elevated elements, are.
Okay, so because I think some of the confusion, and it's self-created by our industry, is because we've called it the balcony bill, and it's everything. It's everything that's, I think 6 feet off the ground.
Yep.
So like you said, stairways, catwalks, anything that's elevated that is intended for people to walk on, essentially, right?
Yes.
And the visual inspection, again, this is language from the bill, needs to be a sufficient number of units to provide 95% confidence within a margin of error of plus or minus 5%. What does that mean?
That's a great question. And to be honest with you, I've asked a ton of people for clarification. I've even gone out to statisticians to try to figure out exactly how to come up with a 95% confidence rate with a margin of error of 5% on top of it, and I get totally vast answers from everyone. I've yet to get a consistent answer of this is how you do it. And so in the end, it depends on how many of those elements there are. So if there are only 10 balconies, then I'm inspecting 10 of them. If there are 300 balconies, then I'm going to take a random sampling. We're going to create a matrix of it. We'll take a random sampling where we can inspect, at least in a case like that, somewhere around, I would say if it's a case of 300, we'd probably inspect around 250 to 270 balconies. Knowing where it's at. That one is still up in the air, but because they're visual, they're able to go a lot quicker, especially if we don't have to get access through all the different units or anything else. We can use boom lifts from the outside, ladders, drones. I've used drones on some of the inspections that we've done.
That's interesting.
There's different components and different ways of handling it. But really what we're looking for is any sign of water intrusion, staining, anything like that.
And there's no destructive testing. So we don't have to get up there. We don't have to poke anything, rip anything open.
So no, we don't have to do destructive testing during the initial investigation unless we see signs that there's a potential for water intrusion in it. So if we see massive staining under a balcony where it looks like wood is sitting on top of like your stucco or your drywall sheeting, then that inspector, that architect or engineer could then say, hey, this is worrisome to me. There are signs that something isn't right there. Or the waterproofing is pulling up and delaminating from the edge metal, and it looks like there's water intrusion under the waterproofing membrane. They can say, this doesn't look right here. I want to open this thing up. And so at that point, you can call for a destructive testing on those specific elements that the architect or engineer says, this doesn't look right, and we need to do further inspection.
And Tim, that is the inspector's, that's the engineer's determination. So if the engineer comes back and tells the board, we need to dig deeper, that's not a board decision, that's the engineer's decision, to my understanding. Is that correct?
Yeah, that is correct. And to go back to that point, though, I think it's important to identify the statute does require a visual inspection of the load-bearing components. So if the load-bearing components are concealed, you have to destructively test to visually inspect them. So in a closed deck system, you're going to have to open it up to visually inspect the load-bearing components because they're not exposed for visual inspection, correct?
Yes.
Okay. Yeah, so I think that's a interesting thing. But yeah, the determination is on the expert to make those calls, and the board will not be, they don't have the discretion to walk back a recommendation from one of the experts, yeah.
Okay, so if the engineer says it needs it, it needs it.
And it also talks about different ways to do that. I mean, you could use a borescope, you can use infrared. You don't have to take things apart to see if there's any potential moisture inside of it. If you're looking at the exterior, elevated elements, and if there's a wood component that's behind it or underneath the stucco surface, there are ways of inspecting that before you get to ripping the bottom of it open and seeing it visually. They list different ways that you can inspect.
Like what you hear so far? Make sure to subscribe to the Tinley Talks podcast at tinleylaw.com and never miss an episode. This podcast is made possible by listeners like you. Thank you for your support. Now let's get back to the show.
Yeah, I just think it's important to understand that it's going to be the inspector's call to determine if it needs further inspection and what's going to be the appropriate way to conduct that inspection, whether it's borescope or whatever tools that we're going to use. And then the other thing is, it says a sufficient number of units to provide 95% confidence. That doesn't mean 95% of the units. That means 95% confidence of all the balconies and 95% confidence of all the stairways. It's each element or each component, not necessarily the unit as a whole.
That's correct. And let me, not to get too academic here, but what they're calling for here is actually really complex, and you kind of identified it. It's not, there's not a lot of agreement on what this means, but to my way of thinking, what they were trying to do is integrate methods that are commonly used in construction defect litigation to allow an association to not have to look at every single balcony, but then based on the sample set that was selected to determine within a reasonable margin of error that this is representative of everything out there. So like in construction defect litigation, a statistician will be retained to create a randomized list of units that are then tested. And then if the testing protocol is followed to the statistician specifications, we can say within a certain margin of error that whatever was identified with those sample set of units is representative of the project as a whole. And based on my discussions with statisticians that we had used in the past, the margins of error depend on the results you get back. And so this is problematic because in a project of 100 units, the statistician may say, you start with 20 units and here's the list and go test them. Based on the results of those inspections, that will affect how many more units you need to test to get within a 75% margin of error. So it's really technical. And as counsel to associations, we're making the recommendation that, statisticians should be involved with this, because unless you're doing 100%, getting to a 95% confidence interval it's a challenge, and it's something that if it ever was litigated, if you, in the absence of that expert making that recommendation, you could have some challenges with it. So, but you're right, it does have to be based on the products, because you can't look at decks and can't lump them with walkways and other exterior elevated elements. They have to be isolated by product type to get within those numbers. Yeah.
Okay, so it's each association is going to be different. They're all going to have different requirements, right? There's not going to be a hard and fast rule.
definitely not.
No, and that's one of the hard parts too. Is managers have approached me and they've said, well, how much does this cost, right? I mean, I'm sure that's going to be the number one question. Well, what do we reserve for this? Mm-hmm. And unfortunately, it depends on each building type. How many elevated elements you have, how big your building is, what the access is to all of those. Am I going to be able to, do I have to go through every single unit to get onto these balconies or walkways or whatever the case may be? And when that is figured out, then we can give you budgetary pricing. And so that's why, we do consultations and everything else ahead of time. But yeah, there's no hard, fast number of $150 a balcony. That doesn't exist.
Yeah, it sounds like managers and associations are going to have to work with the reserve analyst and kind of reserve for a worst case scenario, because if we start with 20 decks and the statistician says, no, we need more, we don't really know how much it's going to cost until we actually get into it and find out what we find.
Yeah, absolutely. And that's something, that we've, as this legislation has been rolled out, obviously we've been working with a few communities that have retained architects and engineers to kind of begin the process of inspecting this. And there have been some interesting proposals. So in associations where, and Paul, you can probably speak to this better than I can, there's some communities that have closed deck systems and there's no way to visually inspect the beams that come out to support these decks. And so, as you point out, you can do borescopes and things like that. But some of the proposals that they're evaluating is whether to put in kind of louvered access doors, so that it's a larger upfront cost. But given that they're going to have to do this every 9 years in perpetuity, there might be a significant cost savings over time to just have access doors where someone can go up, and then you can do 100% inspection. You save the cost on the statistician, and you're confident that everything is performing the way it should.
But then you have to make sure that you're not breaching fire-rated assemblies.
Totally.
And so that's what we're up against too, where they're like, hey, we want to put access doors in these walkways or in these private decks. And then we look at the plans, we're like, yeah, but this is a fire-rated system.
Yeah.
And so to put an aluminum access door in a fire-rated system breaks the fire rating. And so there are certain fire-rated access doors that you can order and get, but then it gets a little bit tricky. So yes, absolutely, because there's going to be additional inspections in the future, it's good to be able to just open an access door and pop your head up and say, okay, everything looks good. But the fact that you have other assemblies at play and other ratings at play, it gets a little bit tricky.
Yeah, absolutely. And that's why you're absolutely right. It's case-by-case basis, and that's why you work with the experts to make those determinations, because you could very well, like you say, come into a situation where you to do that, you're going to have much bigger problems down the road. So, absolutely.
Okay, so we've got our statistician, we've got our engineer, we go and we inspect all of the units, we get our findings, and then there's supposed to be a report. The engineer is supposed to have a written, stamped, or signed report. That report then gets incorporated into the reserve study. So I think one of the differences between SB 721, the apartment bill, and SB 326, the CID bill, was that the apartment bill had a repair requirement, that repairs had to be made within a certain time frame as a result of the findings. SB 326 doesn't have that repair requirement, but it says that it needs to be incorporated into the reserve study. So there's still a funding requirement, it sounds like, and I think that because it's part of the reserve study now, the membership is put on notice, so there could be a liability issue as well if we just put the report in the files and don't really do anything with it. Do you see that?
I think the main distinction point in terms of what they find during their inspections is going to be either it's a life safety issue or it's just normal maintenance. So the normal maintenance issue, yeah, we'll go into the reserve study and they'll say at the end of it, make sure you're recoding these every 5 years, make sure you're coming back to do your inspection in 9 years. We see a little bit of staining here, but it determined it's not anything that needs to be inspected or repaired right now. But we suggest that you come out and take a look at it in another 3 years on just this element or whatever the case may be. In that case, yes, there is no requirement to go out and do a repair immediately. But if there's a life safety issue, there's a reporting function that has to go in where they notify the city building inspection, and that the building department will then come back and say, okay, well, we've been identified, we've been told of a life safety issue here, and that area needs to be deemed off limits, you red tag it, and then it almost forces a repair. Mm-hmm. So while it doesn't say you have to repair it, it basically says if you don't repair it, you're not going to be able to use it, because the building department's going to come out and red tag it.
Well, and I believe that the building department, somewhere in the legislation, and Tim, correct me if I'm wrong, but I believe that there is language in the legislation that gives either the building department or code enforcement or whatever city department is going to be enforcing this, that they can charge the association for their costs to enforce, I believe. Yeah, it says local code enforcement shall have the ability to recover the enforcement costs.
Yeah, that's correct.
So you were saying, Paul, so if there's immediate threat to safety, that report to the local code enforcement, that has to be done within 15 days of completion of the report. So it's an immediate threat to safety. Code enforcement needs to be immediately notified, which essentially is going to trigger a notification from the city or the county to the association that this needs to be corrected now.
Yes.
And then,
and that's when it gets tricky for HOAs.
Right.
Because a lot of these HOAs, at least some of the ones that we've been called out to look at so far, they're 30, 40 years old. They know they have issues, and they've neglected maintenance, and they've neglected, and they've put it off. And now they've called us out because their manager's on top of it, and they want to get out ahead of the rush that's going to be at the last moment of this. And we find something, and we say, this isn't safe, this isn't right. And sets of balconies or walkways are no longer deemed safe, and they're red tagged, and we've alerted the building department. And then the HOA comes back and says, well, how are we going to do this? Because our reserves are at 20% or 10% or whatever the case may be is. Even if they're 100%, they still don't have the money sometimes to come out and do that. And so it gets really tricky for the associations where they feel they're shooting themselves in the foot, but really what they're doing is they are saving lives, legitimately saving lives, by making sure that they're keeping their building safe, and they're not having their homeowners walk out onto unsafe conditions, because the liability that is huge, and actually having this bill out there saying you have to inspect, and if you don't inspect and someone falls through, I mean, that's 100% on the association.
Well, and there's a huge difference between a rear balcony, an extra balcony that's off the side of the unit, off the bedroom, versus like where I live. It's a front balcony. I go up the stairs, I walk across the catwalk, and I walk across a front balcony to my front door. So if that gets red tagged, I've lost access to my home. So that creates a whole other issue where now the association is essentially prevented, or the building department has prevented a homeowner from access, and that usually is a PR nightmare for the association, to say the least.
But wouldn't you rather lose access to your front door than fall through your balcony?
Oh, absolutely. Absolutely. No, it absolutely needs to be done. But I think that it's one of those things where when the association has been burying their head in the sand for so long and has been deferring maintenance, because if we're getting to the point where we're red tagged, there's deferred maintenance, there's underfunded reserves, and when the homeowner can't access their home, that's going to come to roost.
Absolutely. In dealing with construction defect up and down the West Coast for so many years now, I've seen real defects. I've seen real issues inside of walkways and balconies. I've seen stuff that is just ungodly unsafe. And you wonder how it even passed inspection to begin with. And then the fact that these HOAs have been living with this condition for so many years. I've got on balconies before, and I said, I can't be up here. I'm not a small guy. I need to get down, and I'm not going to let my team up here until we do emergency shoring and get it safe. I've seen that many, many times. And then now when you think of those HOAs that haven't done their inspections, and they're 20, 30, 40 years old, and they have these elements that are just rotted out from the inside, there are lives that will be saved because of this, but it will have a financial impact on the association.
I think our firm has taken a different position than several other in the industry. Most of the time when we get hit with new legislation, we feel like it's so onerous on the association, and it's going to be so much more expensive, and we feel like the legislature just keeps messing with our industry. And when this piece of legislation came out, our firm kind of took a different position and said, this is the legislature making the boards do their jobs, right? The board and the association has a fiduciary duty to maintain the assets of the association. That's their job. It's not their job to keep assessments down. And so this bill essentially puts the board on notice to say, you have a fiduciary duty to assess properly so that you can properly fund reserves, so that you can maintain these exterior elevated elements, and as you said, to protect the safety of the membership. I like that there's a component in here that requires that the report be considered and made a part of the reserve study. It says the reserve analyst must consider the opinion in preparing the reserve study. So the association is on notice. There's going to be future funding requirements as a part of their function to maintain this community.
Yeah, I mean, to your point, I mean, these are all maintainable components, and if they are properly maintained, this should not be a significant added burden, right? So as you say, as long as the board is discharging their obligations to the community, maintaining these components, it gets built into the reserve study. It shouldn't have a significant impact on the association's finances. In the beginning, it might for a few communities that have been negligent. It's going to create some issues, but going forward, once it's done right, everyone will be better off for it and safer.
Yeah, absolutely. The newer communities, the statute says that they're supposed to get their first inspection within year 6, I think, or at year 6 for anything that is built starting January or get their certificate of occupancy or allow people in the building, basically. So 6 years from now for a new building, they have to get their first inspection. And I think that was done on purpose because there's a statute of limitations of 10 years for construction defect. And so they're allowing those new buildings the opportunity to inspect for potential defects, go back, through SB 800, which is the Right to Repair Act, go to the developer and say, hey, we've noticed some issues. And then from that point on, it sets up that every 9-year inspection criteria, which you're not going to be in a position where you're 30 years old and you don't have the funds to do it because you're going to be inspecting it right. It is just those HOAs that are 30 years old and don't have the funds right now that are going to be more impacted than the other ones, but they also need to be made safe.
Right. And it's going to become a part of the reserve study. The report itself is supposed to be maintained as a record of the association. So I believe that it could mean, it doesn't say that it is a quote unquote association record, but it does need to be kept on file with the records of the association. So it may or may not be available for member inspection. But just the fact that it's being incorporated into the reserve study, that reserve study gets sent out to the membership annually as part of the disclosures. I think that it's difficult for an association to do their first inspection by 2025 and then have 9 years before they have to do their next inspection. If at the end of that 9 years, if we're not properly funded, I think it's harder for the board to say, well, we didn't know, because they think that they did know, and there's a report on file that said that they should have known and that they should have funded appropriately. And so if there's a special assessment, I think there's a possibility of liability issues and personal liabilities, I think, for board members who don't take these reports seriously and act appropriately.
Yeah, absolutely. I mean, they need to, if the board is on notice and has knowledge of issues through these inspections, they need to act on them so they can work with the professional that was retained for the inspection in conjunction with their actual repair contractors to do what they need to do to make sure, again, people are safe and that they're discharging their ongoing maintenance obligations. Absolutely.
So we're talking a lot about funding issues and funding for the repairs themselves. What about funding for the inspection itself? Is that something, do you think that that's something that they could start funding in their reserves? I mean, we're at 2021, so we have 4 years before our deadline to finish the inspection. We're talking about some of these communities that are 30 plus years old that may be underfunded. We're talking about how expensive it could be just to do the inspection itself and the engineer and the statistician. Do you think that that's something that they can start reserving for? Yeah,
everything that's going to be required to comply with this new legislation should get started now. You don't have to do your inspection today, but you need to get the wheels moving. So get an expert that complies with the requirements of the statute, begin the discussions, figure out what the inspection protocol may look like, how many units we need to get into, are we going to do 100% or less than? With the use of a statistician. Are there alternatives that we can do to minimize the cost of this in the future for ongoing inspections? But they absolutely should get started now because there's tens of thousands of common interest developments in California. Many of them will fall under this new legislation. And if everyone waits to the last minute, the experts that are qualified to do the work in conjunction with the repair contractors will be in short supply, and you could very well be in a situation where you will not comply in time with this legislation and get exposed to liability.
Yeah, it's going to come down to supply and demand. And the amount of people that do this industry, it's a small, industry that of people that can do it. So in terms of the cost and the association of that cost, people need to get on this now, and they need to call out for consultations. And that's something that we do is managers will call and just say, can you come out and tell me what we're up against here? But they're looking to do this. We know this is something that we're going to have to do in the next couple of years. Can you at least come out and tell me what we're up against? And we'll go out there and we'll do a free consultation. And there's a lot of companies that will. And we'll say, yeah, you know, the way your building is put together, do you have as-built plans and elevations that are going to help us? Is there any unit matrix that you already have? Or are we going to have to create all this stuff from scratch?
Today's episode is brought to you by Altera Assessment Recovery. Altera provides comprehensive attorney-supervised assessment collection services to community associations throughout California. Trust us with your collection needs. We'll get the job done right, and as quickly and efficiently as possible. Altera Assessment Recovery. We're the collection team you've been looking for.
And then based on that, we can give them some budgetary numbers. And so it's not like it's an unknown number until we start the inspection. You can call for a consultation ahead of time. We'll come out there and tell you if we see anything that looks like it's going to be a little bit tricky, or we'll also let you know if there's some areas that we think might be a problem if we get into it. Just FYI before we go red tagging things as well.
And what about associations that are already in the process of doing their normal maintenance? So we know that we're due to resurface our balconies. You know, we know that we're due to take a look at our balcony, or we have wood railings. You know, it's time to take a look at those. As you're putting those proposals together and you're working with those associations, do you talk about alternative materials? Do you talk about getting rid of some of the wood?
No, not only that, but we're also combining the SB 326 inspections with these repairs. And so if we're out here and we're repainting the exterior of your community, for example, or recoating all of your walkways or balconies, we'll say now is the time to check this box. We're already out here, we're notifying all the residents, we're in the area, we have our boom lifts up, we have scaffolding, or whatever the case may be. Now's the time when you combine that with your SB 326 inspections and just get it done with, get it off the books. And it saves cost in doing that as well, because access turns out being somewhat of a significant cost to doing the inspection, just getting on the balconies. And so if you're already there, you're able to save money.
Because they don't have to wait until 2024 to do the inspection.
No,
if we're already working on the elevated elements now, let's just inspect them now and get it done and over with.
I think we've done about 20 of them already, just and before the law even, it's in its infancy now in terms of coming out, and we've already done at least 20 of them. So I know that it's something that managers are jumping on top of, and especially if they can do it in conjunction with other repairs.
And then they would just have 9 years. So if we're doing painting or deck resurfacing now, and so we're going to do the inspection now, then it's the next one is 9 years from now, not 9 years from 2025.
9 years from the date of the inspection.
Great. That's really great advice, because I think a lot of associations and a lot of managers are thinking, okay, well, I'm doing my deck resurfacing now. It's an opportunity to kind of take a look at them and plan for the future. But I think that a lot of us are thinking 2025. I don't really need to think about this until 2024, 2025.
Yeah, well, it's so much more cost effective too when you're already mobilized. The team is on site. The deck elements are largely exposed. You have access that you had to coordinate with the owners. I mean, you've taken out so many of the logistics issues already. So it's incredibly wise to do it in conjunction while your vendors are already mobilized doing other work.
Yeah, chances are over the next 4 years now, you're going to have some repairs to your building, or some type of a repaint or of a balcony. You said I think there's 50,000 plus HOAs in California. And chances are a lot of those are going to have some type of work done in the next few years. And so those managers need to just be, understanding of the fact that there is a requirement that's looming, and they should be putting that in front of their board, saying, hey, now's the time to take this on as well.
Now, if they are dealing with cantilever decks, if they are dealing with predominantly wood structures, are there other materials? Is that a possibility to do some capital improvements and take some of that wood out? They might not be able to get all of the wood out entirely, but can they change some of that?
There's always a possibility of doing that. It comes down to, cost benefit. Does it make sense for us to pull these things out? Now, if they're rotted and if they want to come back in with some additional or alternate materials, absolutely no problem. And I think that's a good thing to consider when you're looking at elements that have rotted over the years. But if it is just 40-year-old wood, it's done its job for 40 years. Replacing it with wood is always going to be cheaper than coming in with some other, alternative material. And so only in certain cases would we recommend coming in with something different.
Well, I think, Paul, I think you made the best point, and that was, there's no reason to wait. Go ahead and get started now, because we're talking about something that needs to be done within the next 4 years. If we're actually looking at our regular maintenance for our exterior elevated elements, we're supposed to be looking at them every 3 to 5 years anyway. So if we're just following our regular maintenance, the course of our regular maintenance, we should be in a position to go ahead and get up there and inspect them and get started on this now.
Yeah. And that's the biggest thing. And I think that's why they've also given 5 years. The only thing that I'm running into is I'm running into these old HOAs who don't have the funds, and they're worried about what we're going to find. And there are a lot of them where they're saying, well, if you tell us, then we know, and then we're on record, and then we have to figure it out. Like there are HOAs that are in a bad spot right now. I don't want to scare anyone from doing what they're required to do by the law, but there are HOAs that we've inspected and we said, hey, you have significant wood rot on these back private balconies and you need to address them. And they've gone through and they've put letters to their members and said, you can no longer go on your back private balconies until we've repaired these. And then they're sitting there saying, okay, well, how am I going to raise $280,000 to repair all these back balconies when we only had $40,000 in our reserves and we have a major drainage issue that's leaking into all of our basements right now as well?
But I think that is precisely the point of this particular piece of legislation, is that the legislatures wanted the members to be able to keep the board in check and to require that the board fulfilled its fiduciary duties. So these associations, and it's usually multiple boards over a course of several years or decades, that have consistently underfunded and have consistently kept their assessments artificially low. And to now turn around and say, well, we want to know what we're in for because we know we have to do this by 2025, but we really don't want you to give us a written report because then you're going to put us on notice and then we're going to be liable. Well, you're still burying your head in the sand. You're still not resolving the issue. And where you would have 4 years to properly fund and reserve for this and start raising your assessments slowly so that the membership can ease into those new assessments, now you're putting yourself into a position where now we're going to have a large special assessment down the road because we procrastinated. And to my mind, I think that is the board making a knowing decision, and I think that puts board members at personal risk of liability, and I question whether or not that would be something that the insurance is going to cover because they knew better and they chose to bury their head in the sand. And I think that's why we have this legislation now, is because that's been going on for too long and kids got hurt and kids died, and that can't happen anymore.
And it's not just that one incident. There's plenty of other incidents where balconies have collapsed and walkways have collapsed and walkways that need emergency shoring because portions of them have collapsed. Mm-hmm. This is a real issue. It's not based off of one single defect that happened. Multiple, I don't know what percentages of HOAs go into defect litigation, but it's something substantial. And there are legitimate issues that are festering underneath these walkways that, left unchecked, are going to hurt and potentially kill more people, God forbid. So it's a real piece of legislation, and I applaud them for pushing it forward. And now it's just getting the education out there to the boards and to the managers, and trying to help them figure out how they're going to do it. We do these consultations I talked about, and we're calling them kind of our pre-SB 30 or 326 inspections, where we're going to walk with you and the board, and we're going to say, hey, you might have an issue here when we get out here with our architects and engineers, and so you might need to figure there's going to be some potential costs coming in, and you need to start thinking about how you're going to take that on already. And
yeah. That's the recommendation that we're making is, do a soft inspection. Even if you don't do it with a structural engineer, use your general contractor that you work with all the time.
100%.
Go out and do a soft inspection. Get a general understanding of what it is that you're dealing with so that you can start funding for it. If you need to go get a loan, now's the time to start working on that. There are financing options that are available, but if you wait until the last minute, as you said, Tim, and Paul, you're going to run into supply and demand, and you're going to run into not having engineers available to do the inspection, contractors to make the repairs. whether you may or may not be able to get a loan depending on, the financial status of your association versus if you were to start that right now and really start diving into what's needed.
And to do that in conjunction with any repairs that you do over the next 4 years, I think is crucial. Mm-hmm. I always preach to HOAs that there's like homeowner fatigue, right? Don't keep coming back to the same homeowners with different projects every 6 months, every 4 months, every year. Just understand what your outlook is for the next few years. Get it all done, rip the Band-Aid off, take care of your inspections. Don't come back over and over and over again, because all you're doing is wasting money and time, and it's not efficient for you as a board and as a manager. Understand what you have coming up and plan for it to all happen at the same time.
That's great advice. Well, that's our show for today. Thank you all for listening. We'd also like to thank Paul Pigott for your time and expertise today. Make sure you visit our website at tinleylaw.com if you haven't already, where we break down this episode, and link to our blog article, SB 326 Signed, Balconies, Branches, and Builder Defect Actions. Then stay tuned for our next episode.
To share or subscribe to the Tinley Talks podcast, visit us at tinleylaw.com. There you can find links to everything discussed in this episode, locate helpful resources, check out other episodes, and submit questions for future topics. And be sure to tune in next month for our next episode. As always, the views and opinions expressed by the podcast, its presenters, and guests do not constitute legal advice. For more information on the topics discussed in today's podcast, please consult with your association's legal counsel. This is Tinley Talks, presented by Tinley Law Group. Your community, your counsel.